How long will Ripple's lawsuit against the SEC last? Which new Ripple partner will be able to influence the situation in court? We will answer these questions in today's video. There has been considerable activity surrounding the sealed papers considered vital in arriving at the ultimate verdict in the current court action between Ripple and the United States Securities and Exchange Commission, SEC. Specifically, on February 16th, defense attorney James Phelan tweeted that media personality and Forbes senior writer Rosalind Layton had filed a petition to acquire the confidential Hyman speech record. According to the petition filed by Rosalind, the First Amendment and federal common law provide a strong presumption that the press and public have access to court papers. The petition claims that holding the court responsible requires using this particular privilege. In addition, Layton claims that the SEC has been inconsistent in its oversight of cryptocurrencies, arguing that the agency has yet to provide definitive standards for the regulation of the industry. Given the SEC's refusal to provide explicit regulatory guidance on cryptocurrencies, Layton claims that immense significance has translated into intense public scrutiny of Hyman's speech, which is the only instruction anyone within the SEC has offered crypto stakeholders to avoid the wrong end of an enforcement action. Carl Sekir, the proprietor of Sekir PCE, a legal firm specializing in Supreme Court and appellate work, likewise concurred with the motion. We recently filed this application for permission to intervene in the SEC's EV Ripple lawsuit seeking billions in penalties from Ripple based on their cryptocurrency XRP, which the SEC argues is an unregistered securities, Sekir said. Curiously, minutes after the motion was filed, Forbes mysteriously pulled an article by Layton that provided a critical analysis of the apparent unjust handling of Ripple by the SEC. Ripple's argument hinges on the Hyman speech, given by William Hyman, the SEC's then director of the Division of Corporate Finance, in June 2018. The speech is widely seen as containing the SEC's view on whether or not cryptocurrencies should be classified as securities. Throughout this hearing, Ripple's attorneys have been asking the judge to force the SEC to hand over the relevant records for examination. According to the company's interpretation of the Hyman speech, XRP would be treated similarly to Bitcoin, etc., and Ethereum, ETH, both of which were designated non-securities. As insiders inside the SEC did not comprehend the instructions, Layton said that public access would thus be vital in allowing the public to judge the soundness of Ripple's fare. Notice argument. The SEC has specifically charged Ripple with operating unregistered securities offers through the XRP token sale. There's been much curiosity about the possible conclusion since some legal experts have questioned the SEC's categorization of securities. In this piece, attorney John Deaton for XRP holders argues that the agency may lose the summary judgment because of the uncertainty surrounding the proper designation of XRP as a security. Deaton, responding to Layton's most recent filing, said the information contained inside will be made public in due time. This is exactly what I was talking about when I predicted that the leak of the Hyman emails would prevent any chance of a settlement. You put the genie back in the bottle, he said. While waiting for the final verdict, SEC has also requested that other records pertaining to expert witnesses be kept under seal. The crypto community as a whole has been critical of the move, prompting Ripple to take action in opposition. The cryptocurrency industry is waiting with bated breath for the summary ruling in the ongoing legal conflict between Ripple and the Securities and Exchange Commission, SEC. As a result, there's been a great deal of attention and discussion about the case and its potential effects on the regulation of digital assets in the United States. In light of this, the SEC has increased its regulatory control of the cryptocurrency sector in the last week, prompting strong criticism from certain industry players who fear the agency's approach may be biased. U.S. defense attorney and frequent commenter on the Ripple and SEC cases James Phelan has renewed his request for SEC Chairman Gary Gensler to step down, following the SEC's crackdown on staking. Paxos, a cryptocurrency startup, is being sued by the SEC on the issue of its Binance USD stablecoin. The regulator has determined that the stablecoin is a security that was issued in violation of the law. It's important to remember that the SEC is also suing Ripple for offering XRP tokens as unregistered securities. In this passage, attorney John Deaton for the XRP holders in the SEC action criticized the deceptive nature of the securities classification. Most cryptocurrencies are deemed securities by Gary Gensler and the SEC, who maintain a singular emphasis on the token. Tokens are not securities, but the issue is that important and knowledgeable individuals are spreading the false narrative that they are. Deaton also praised Coinbase CEO Brian Armstrong for his statement that the company's staking services do not constitute securities. Meanwhile, Deaton has joined another class action complaint against Ripple in which investors accuse the firm and its CCO, Brad Garlinghouse of Marketing's XRP, as an unregistered securities and demand compensation for their losses. For their part, the plaintiffs have asked the court to label XRP a security. Deaton has decided to file an amicus brief in this matter. Ripple's general counsel, Stuart Alderoty, has called the SEC's handling of the lawsuit against the company misguided. As with the SEC, Deaton called their reasoning inconsistent and schizophrenic when it came to the idea of a common industry. He further noted that the court has the option to rule against a summary judgment. In addition, the crypto community has been following the dispute between the SEC and the blockchain-based sharing platform Elbri with great interest, despite the fact that the final decision of the case is still up for debate. In this case, the SEC filed a lawsuit against Elbri because the company was selling LBC tokens without first registering with the SEC. The court, however, determined that LBC tokens are only securities when sold directly to the public. After the verdict in favor of Elbri, calls for the relisting of XRP have increased. Particularly, XRP supporters have been petitioning Coinbase and Binance to bring back the coin. With more and more people getting behind this cause, it makes you wonder whether they'll be able to get the exchanges to relist XRP. The SEC case is still underway, and it is unknown whether the regulator would push out the timeframe for a summary judgment over the currently projected date of March 2023. Even though the company's future is clouded by legal ambiguity in the United States, Ripple has continued its rapid expansion in other countries. When Brad Garlinghouse joined Ripple Labs in 2015, he certainly didn't expect to be at the center of one of cryptocurrency's greatest legal disputes. Garlinghouse has extensive company experience and fights regulators. Garlinghouse attributes his work ethic and honesty and responsibility to his Midwest heritage. Can Ripple's CEO fight for blockchain's future after working at some of the internet's top companies? Who leads Ripple Labs against the SEC with Chris Larsen? We must go back to comprehend Garlinghouse's crypto market ambitions. Charles Hoskinson and Gavin Wood are computer science, trained blockchain leaders. The XRP founder comes from a business and economics background, not New York or San Francisco. Hutchinson, Kansas, reared Brad Garlinghouse. Garlinghouse was raised in a tiny Midwest town and values family and community. Wichita Southeast High School and the University of Kansas gave him a BA in economics in 1994. Garlinghouse completed his MBA at Harvard Business School in 1999 with bigger goals. Garlinghouse interned at Allen Company, an investment banking company, while college. Garlinghouse worked as a J.P. Morgan analyst for 6 years after graduating from Harvard Business School. These years exposed Garlinghouse to Wall Street and the World Economic Forum. Early internet giant Yahoo hired Brad Garlinghouse. Garlinghouse developed Yahoo Mail as Senior Vice President of Communications and Communications and Community. These platforms are the foundation of the current internet. Garlinghouse is most known for the Peanut Butter Manifesto after his contributions to Yahoo. This famous memo called on Yahoo to simplify processes. Fintech companies shared the message. In 2009, Garlinghouse became president of consumer apps at AOL. He developed AOL Mail and instant messaging in this capacity. Garlinghouse also ran AOL Ventures. Bebo's purchase presented fresh issues. AOL Ventures sold Bebo 2 years later at a fraction of their acquisition price, making this move a failure. Brad Garlinghouse left Silver Lake Partners to work on blockchain and digital assets. Garlinghouse identified Dell MC, Airbnb, and Alibaba Group investment prospects as managing director. Garlinghouse was also a senior exec at Hightail. Garlinghouse made sure Hightail kept offering creative productivity solutions to its global customers after rebranding from Usendit. Garlinghouse left corporate life to join Chris Larsen at Ripple Labs in 2015. Since then, Ripple's CEO has led its growth in XRP development. Garlinghouse has advocated using blockchain to address banking regulations and cybersecurity. His outspokenness has made him a target of the SEC's cryptocurrency assault. The SEC's lawsuit against Ripple Labs has tarnished the blockchain company's CEO. The complaint seeks to clarify how the SEC regulates XRP. Brad Garlinghouse and Ripple Labs call XRP a currency, whereas the SEC calls it a securities. Ripple Labs and XRP have suffered from the litigation, with Coinbase removing the coin. Fear, uncertainty, and doubt have clouded XRP's prospects in previous bull markets due to reduced trading liquidity. The lawsuit should be resolved by mid-2023. The SEC's crypto and blockchain crackdowns continue. The SEC penalized Kraken $30 in February 2020. 3 for their staking offering.